Samira, and most importantly, Dave, the expert for coming in and talking to our team. But no questions on my end.
Okay, perfect. Just if you don't mind in the introduction, as you can just hear, I wanted to do it now so it doesn't interrupt anybody. But if you were to say that this is being recorded.
Okay.
And then it's up to you guys. You guys want to just let everybody in now and give them a few minutes?
Yeah, we're a minute till, so let's let them in.
And we're starting. I will go on mute from here.
All right, Zach and Daniel, just give me the green light when you're ready to start.
I think we can go ahead and get it started, Corey.
Okay, perfect. Well, first off, I want to thank everybody for joining us for today. This is one of our first Apex-wide meetings and a very important one that we'll be discussing SBIR data rights. Before we get started, I do want to thank Samira White, Danielle Grunwald, Rodney Cowitt, and others who have put this event together for us today. We have a very special guest in the room, Dave Metzger, who has dedicated his professional career to the SBIR space and is a world-renowned expert in SBIR and specifically SBIR data rights. And so I know our teams have quite a bit of questions about SBIR data rights through our day-to-day operations in Apex 4 and our relatively recent, I would say, entry into SBIR space in 2018. And a lot of questions come up about how to apply the data rights and et cetera. And so Dave is here to kind of give us some background on that, to be able to answer some questions as well. I also want to thank our partners in OGC who are on the call with us today. So the general counsel legal team that supports our office today is here to help us understand a little bit more collectively what SBIR data rights means, and then to also have that spearhead us into future conversations about how we can apply the SBIR data rights to our procurements and our projects. So thank you for our OGC team being here as well. So I don't want to spend too much time, but I do want to introduce Dave. As I mentioned, Dave has been a lifelong proponent of the SBIR program. He's been instrumental in developing the laws on how SBIR is enacted and continues to be focused on ensuring that SBIR small businesses understand what their data rights are and how to best apply them to the circumstances to make themselves competitive in the marketplace. Dave is a retired partner of Arnold and Porter. He shares a couple of things in common with Rodney Cowitt. So Rodney is probably one of the most passionate people about SBIR that I've ever met. And I would say Dave Metzger is certainly going to rival that with all of the experience and efforts that he's led as well. The other thing he shares in common with Rodney is that he's a Tibbetts Award winner. And that's a very prestigious award by the SBA that recognizes folks that are doing extremely important work for SBIR, whether it's the customer agencies, contractors, or acquisition professionals. So Dave brings a wealth of knowledge, and we certainly are happy to have him here today to talk a little bit about the program and how we can apply data rights to our procurements. So with that, I will pass it off to Dave.
Thank you, Corey, for those kind words. And on your screen are just a few of the agenda items that we're going to go through. We want to discuss what are data rights, what government phase 3 awards are, why protecting SBIR is important, to what agencies that applies, and when and how to mark SBIR data. So we have quite a bit of issues to get through. So buckle your seatbelts and put your trays in the upright and lock position, and let's take off. Next slide. First, let's discuss what are data rights. Next slide. They grant the government first a non-exclusive royalty-free paid-up worldwide license. That means that the government has a license to make a limited use of the SBIR data you give to it, but it can't publicly disclose the data as long as the protection period remains in effect. That last part, not publicly disclosing the data, is one of the most important attributes of SBIR data. The data rights protection changed in 2019. It's now 20 years from the date of award. That's a fixed period. The SBA eliminated what was known as the rollover provision, which extended prior award protection periods to like 5 years after the Defense Department contract or 4 years after the end of the civilian contract. That extension period is now gone, and the 20-year period replaces it. Government disclosure of data like SBIR data could actually ruin the SBIR's potential market. If anybody can copy it and big firms could make the product, they could preempt the SBIR's market very easily, and the SBIR couldn't compete with them. So the non-disclosure obligation on the part of the government is a market protecting provision. Next slide, please. There are 3 essential attributes of SBIR data. And I'm going to refer to SBIR data. I won't keep repeating STTR, but under the new policy directive, they both are treated equally. First of all, they are recorded information. That is, they're information reduced to writing. So SBIR data can be source code, sketches, drawings, formulas, equations, reports, any technical descriptions of the SBIR effort, and so forth. In a deliverable, the name of the firm, the address of the firm, etc., are not SBIR data. So all deliverables are going to have some SBIR data, some not, and we need to know how to address those, how to recognize them. First, they're reduced to writing. Second of all, they're technical in nature. General statements and non-technical data don't qualify as SBIR data. So I interpret that to mean something that abuts right up against science is probably going to be technical data, but more general statements are not. Next slide, please. And there was one other aspect to that, and that is SBIR data are generated under an SBIR funding agreement and are appropriately marked. Now, they have to be generated under an award that is defined as an SBIR funding agreement. That's a broad term for any type of contract, grant, or cooperative agreement or other contract or agreement that transfers money to the recipient. But notice they must also be appropriately marked to qualify as SBIR data. That's new under the new policy directive, and we're going to talk about marking later in this presentation. Proprietary data developed by the firm's own private expense are not SBIR data, and they should be appropriately marked with private confidential markings. Also, hardware is not SBIR, STTR data. I'm often asked, should we mark a black box if we deliver it to the government? And the answer is no, for two reasons. First of all, a black box is not recorded or written information. And second, it's visible to the naked eye, so it can't be subjected to the non-disclosure obligation. So for those reasons, hardware black boxes are not SBIR data and should not receive the marked legend. Don't mark, therefore, hardware of any kind as SBIR data. However, software in a black box can be SBIR data if generated under an SBIR funding agreement. Computer code is always considered technical and in writing. Even when it's inaccessible, when the black box is integrated, manipulated, or otherwise used. So as long as the code remains hidden when the program is run, then it remains SBIR data. Note that an agency receives only one seat for computer program data that you give it. It can't send the data around to all kinds of computer program to all of its employees and act as though it just got a free product from the SBIR firm. That's part of what was referred to earlier as limited use of the data. Under the SBA's policy directive, any data that are delivered must be marked with the appropriate SBA data rights legend. We're going to talk about that. There's a slightly different legend for DoD now. Next slide. It's important to know that the directive, the policy directive, despite its term, has had the force of law and is a regulation since 1992, and it binds agencies by law. Some of the agencies look at the word policy and they think it's just something that's aspirational, it's guidance, but it's not law. That's not true. And when you hear that, then you as SBIR firm people need to become teachers and educate them that the new policy directive since 1992 has been issued pursuant to what we call notice and comment rulemaking. That's the type of making of a regulation or rule that resulted in the law that you pay taxes under. So I think that one has a binding effect. So the policy directive does too. Agencies can't change the law. They can't change the SBIR Act or the policy directive and all of its rules and regulations that govern SBIR. They also can't request firms to waive their SBIR data requirements. If that occurs, first of all, remind them that the law gives you that right and they can't change the law. Next slide, please. So we're going to discuss government phase 3 awards. The first question you might ask is why? And the answer is because SBIR phase 3 is the most complicated phase of all of SBIR. Phases 1 and 2 kind of come off sort of without a hitch. And except for sometimes the duration of time between awarding them, it's phase 3 that raises the most questions. And in the government's mind, they're always asking, just because it's a phase 3, do we have to apply data rights to it? So that's why we're going to discuss phase 3 awards. Next slide, please. What is a phase 3 award? Let's define it. In the policy directive, a phase 3 is defined as an award that derives from, extends, or completes prior SBIR STTR effort with non-SBIR, that is non-set-aside funds. I want to just give one sort of bit of history. And that is when we offered that definition to the Office of Management and Budget, they completely objected to it. And the reason they objected to it was that it would result in way too many phase 3 awards. So we had Denny Hastert, who then was the Speaker of the House, who was giving a speech in the rotunda, include this statement in his speech: I want that SBIR policy directive on my desk within 2 weeks. Well, OMB didn't have time to alter our language, so it went in the way I'm just now going to describe it. Derives from means the award phase 3 work in the statement of work traces back to prior SBIR effort, usually a phase 1 or a phase 2, but it could be only a phase 1. You can go from a phase 1 to a phase 3, but there has to be some kind of prior phase 3 work. Extends means that despite the fact that the application under consideration in the current award was never mentioned in phase 1 or phase 2, extends means that that new application can be a phase 3 if it traces back to prior SBIR work. And completes refers to the process of commercializing the SBIR effort into some kind of product or design. Notice the word or. That means that any one of those 3, if they apply, any one is going to make it a phase 3. Next slide, please. Let's discuss why protecting SBIR data is important. Next slide, please. Phase 3 brings with it a whole list of benefits that you don't get from other programs. First, it's the right to award a phase 3 without competition. I like to say without competition. Here's a little bit of a lawyer's note. Sole source is the first exemption from competition under the FAR Part 6, that it has certain exceptions in it from competition. That's not the SBIR exception from competition. SBIR triggers exception 5, the other law exception. And that one says that if there's any other law that authorizes awards without competition, then you can do it. And that's what SBIR triggers. And so it's the SBIR Act and the policy directive that trigger this awards without competition. That's why I like to use the term awards without competition rather than sole source. SBIR, STTR data impose that protection and non-disclosure obligation on the part of the government. The phase 3s are exempt from SBA size standards. So we see large firms purchasing, acquiring SBIR firms, and because they now own that prior SBIR effort, they can receive phase 3s regardless of their size. So these multi-billion dollar firms can get phase 3s. There's no limit on the number, award dollar sign, duration or time between phase 3s. I like to say facetiously that there probably is a dollar size limit on a phase 3. It's probably $1.1 trillion, which is the size of the federal budget, but usually we're not going to award a phase 3 that deprives all other agencies of any funds. The right to a phase 3 mandate, it accompanies the phase 3. The SBIR firm has a right to be awarded a future phase 3 award to the greatest extent practicable. And we're going to discuss what that term means a little later. The award without competition also applies to subcontracts. Subcontracts can be phase 3s and phase 3s can be subcontracts. That's important to know when an agency directs you to work with a large prime to insert your SBIR innovation into a large platform. That subcontract is going to be a phase 3 and must have the SBIR data rights clause in it. The large firm might look at that and say, that innovation is in our area and could compete with us. We kind of don't like it. So when you ask them to give you the SBIR data rights clause, their patent attorney will tell you, well, we don't have that clause in our contract. We can't flow it down. To which you as a teacher reply, you don't need to flow it down. You insert it into our subcontract. Well, we can't do that. Where do you go then? You go to the government. Sometimes the government will say, oh, we don't get involved in subcontract matters. To which your informed reply will be, you're already involved. You directed us to subcontract to this large firm. Help us out with these guys. So you need to know how to work through those issues. The ability to pursue research and development accompanies a phase 3. You can do services, products, production, or any combination of those. I defy you to look at that last bullet and come up with something that those don't cover. Phase 3s can be literally for anything. Next slide.
Dave, can I interrupt you quickly?
Sure.
We had a couple of questions that came in
Okay.
that to see if you could address.
Okay.
The first one is data under the pre-May 2019 funding agreements protected for the earlier period or under the new 20-year period?
The only contract that would be covered by the pre-2019 policy directive would be an award that was made during that period. That award could, which would have to precede May 2nd, 2019 on the award date, could qualify for the old data rights clauses and the rollover provision. But any award after May 2nd, 2019 is going to get the 20-year protection period.
Okay. And the second question, we often get questions about whether it is appropriate to award a phase 3 without further competition if the prior SBIR data protection period has expired. Can you address that?
If you go back to the definition of a phase 3, it has nothing, repeat, nothing to do with whether that prior phase 3 protection period expired. The definition is any award that derives from, extends, or completes prior SBIR effort and is funded with non-SBIR, that is non-set-aside funds. Nowhere in there do you hear that it's contingent on the prior protection periods which may have expired. That also goes to why you can award a phase 3 at any time duration at all.
Thank you.
Okay, let's talk about to what agencies do the SBIR data rights apply. Next slide, please. Phase 3 awards can be made by any federal agency, even if that agency is not one of the 11 agencies that are SBIR program participants. So if you develop something for the Army and the EPA calls you up and says, hey, we'd like to use that, that looks pretty good, you can sell it to them as a phase 3, even though they're not an SBIR program participant. Federal agencies may enter into a phase 3 SBIR agreement at any time with a phase 1 or 2 awardee, regardless of the stage of completion. So literally, 1 hour into your phase 1, you qualify for a phase 3. I remind people of this because I don't see why agencies who want to continue an SBIR to a phase 3 wait until the final report of the phase 2 is issued. Why not start that phase 3 process later or in the middle of the phase 2 process and have it ready to go when that report comes in? Why create a delay? It takes time to develop a phase 3, and so use that time wisely while the firm is finishing up its phase 2. I will say that one of the most popular types of SBIR contracts are what is known as IDIQs, indefinite delivery, indefinite quantity contracts. That's a contract where you can award it as a phase 3 and then have a statement of work that basically is very simple. It says this award is made to advance, and then give the title of the phase 3 under SBIR laws. And then a task order under that IDIQ general contract can be issued for every step of the way to final commercialization, from further research to research and development, to testing, to directing it to work with a major prime contractor, to final commercialization and even sale. Keep in mind, a sale of a phase 3 can be a sale of a product developed under phase 3 can be a phase 3. Example of that, those who are listening, I know, never fell off of an aircraft carrier because he wouldn't be listening. It's a fatal fall. And so a firm designed a nice surface. It's a non-skid surface to paint on the surface of aircraft carriers. Every single barrel they sold to the Navy was a phase 3. Okay, let's go to the next slide, please. Phase 3 commercialization has become a real important issue in the reauthorization of the SBIR Act. Commercializing work that derives from, extends, or completes an effort performed under a prior SBIR agreement is called commercialization. And that can include activities in the military, civilian, or private sectors. Commercialization isn't dependent on the sector. It can be for SBIR-derived products or services. And it can even be a continuation of R&D, which we normally associate with phase 2, but phase 3 can include more research and development, or any one of those things mentioned earlier. Increasingly, agency rules are requiring commercialization to a marketable product. That is because Congress, and some in Congress, are convinced that some SBIR firms only want to receive phase 1s and they don't want to do any commercialization. While I don't think that's largely true, that's the perception, and so it resulted in some changes to the new SBIR Act. And any business awarded a phase 1 or phase 2 or a successor in interest firm becomes eligible for phase 3s. What's a successor in interest firm? A successor in interest can occur through an acquisition. So if a large firm buys an SBIR firm, acquires it, they are buying and now own prior SBIR effort. So they qualify for phase 3s by virtue of that. They can also gain that status through novation. Now, the Anti-Transfer Act, a federal act, prohibits transfer of federal contracts, but you can do it by following a process in FAR Part 51 called the novation process. That lets the government know that you want to transfer the contract. The government approves it with a sort of a complicated agreement. And once that agreement is signed, you then can transfer the contract to another firm. That firm then has access to prior SBIR effort and can gain phase 3s. Or you can even assign, that is, sell SBIR data rights and part of your technology, or a dead phase 1, I call it, phase 1 that's over with, to another firm. And they would qualify because they now own prior SBIR effort. I would caution SBIR firms that selling parts or all of your SBIR technologies, or even licensing them, should be done carefully if you want to continue to stay in business and promote your SBIR technology, so as not to create a large competitor, because that large competitor can outdo you in terms of rapidly creating the final product and marketing it. So be careful about assigning parts of your technology or a phase 1 when you keep the phase 2. Be careful of all that so you don't create a competitor. The SBA Act now has restrictions and requirements on commercialization, and largely you cannot get over a certain amount of phase 1s or phase 2s without selling a certain amount of products, and those are contained in the new act. Next slide, please. If the award requirement for a phase 3 has been made a lot stricter in the new policy directive. And if pursuing phase 3 work is found to be practicable, then agencies are required to do it. Then you must award a non-competitive funding agreement to the SBIR firm. The cite to that in the directive is right there. It's in 4C7. It's interesting that to be practicable has a very, very narrow meaning. It's largely, is the small business still in business? Is it capable of performing? And is it willing to perform the phase 3? That's largely limited inquiry to is it practicable? They have to consider the practicality of pursuing the work with the awardee, and is it available, capable, and willing to perform the work is the only thing that they can ask. If the phase 3 is determined not to be practicable, an agency has to provide SBA with a written rationale for that, and SBA can appeal it if the agency decides it's going to go with someone other than the SBIR firm. I caution you, most agencies won't do that because of the non-disclosure obligation. They would literally be asking the new firm to start over from scratch because they can't disclose any data to it. So that non-disclosure obligation kind of prevents them from actually doing that. And we very rarely see that, if ever. Go to the next slide, please. Let's talk about marking SBIR data. Marking is always a subject of some questions to me. Next slide, please. There are 3 elements to the SBIR STTR legend. The legend is contained in the new SBIR clause, which is located in Appendix 1 of the new 2019 SBIR policy directive. That was a major rewrite, and that's why we refer to it as new, even though it's 2019. It's been amended since, but that new legend has 3 elements. First, the title. It's SBIR STTR data rights. That's the title. It has a 5-row chart in it that must be filled out. You have to supply the funding agreement, the award date, which are both on the title page of any funding agreement, a date 20 years out from the award date, the awardee's name, and the awardee's address. The name and address usually the firm can get right. The paragraph of text describing the government's rights and obligations is a vital part of that legend and must be included word for word accurately. Make sure that it's accurate. Next slide, please. Marking refers to the process of affixing that 3-part legend to a document. Here come the magic words: accurate, completely, and in a filled out form. All agencies have now agreed to abandon the FAR and DFAR clauses and use SBA's new clause instead, which includes the 3-part legend. There's only one exception to that, and that is the Department of Defense amended its original DFARS clause effective March 17, 2020 to reflect the 20-year protection period and SBA's new clause, albeit in sort of new DoD form. The new DFARS 252.227-7018 clause is labeled, here comes an important word, a deviation. And whenever that clause is included in your contract, make sure that the word deviation is in that clause reference. If not, you're getting the old DFARS clause, which only gives you 5 years of protection after the end of the award. You don't want that. So get the 20 years and by ensuring that the 252.227-7018 clause has attached to it the word deviation. It's interesting that the 20-year protection period was the result of a big tussle with the agencies. The agencies only wanted that to be 12 years, which if you take a 10-year contract, that would be only 2 years after the contract expired. And so SBA wanted it to be at least 20 years, and it won that fight, but it had to give up the rollover provision. So now it's a 20-year fixed period. Next slide, please. These are important considerations that are now included in this new policy directive. Failure to mark or to mark SBIR data delivered to the government inappropriately gives the government unlimited rights in the SBIR data. What are unlimited rights? The government can include that data in a solicitation, can disclose it directly to commercial firms of any size, including your competitors. The SBIR firms' main competitors can use them for any purpose, even to develop a commercial product from them and sell it at Walmart. There's just no limit on what the government can do to a failure to affix that legend, that SBIR legend, to a deliverable, or to inappropriately market. You can imagine that the governments would love unlimited rights in your data. And so they're going to look over that legend very carefully to find out if you missed a comma, if you misspelled a word, and then they'll claim, aha, you marked it inappropriately, and they're off and running with your data. So make sure that there are no typos, that there are no idiosyncrasies in that legend you affix to your deliverable. Awardees have 6 months to correct inappropriate or failed markings, but don't forget the government retains unlimited rights to the data until it's corrected. Here's a valuable tip, or at least I think it's valuable. If you find that your data was inappropriately marked or you failed to mark it, don't alert the government to that. Don't write them and tell them that. Don't call them. Fix it and then resubmit it so that the government can say, oh, you know, it's going to take them a few days to fix that. We'll get this solicitation out in a hurry, or we'll disclose this to, you know, a large firm and they can do it. They have that right in the face of an inappropriate or failed marking. So don't give the government notice that that happened. Now, appropriately marking turns the tables completely. We've been talking about inappropriate or failed markings, but appropriately marking your SBIR data, the data constitute trade secrets, and they're covered by the Federal Trade Secrets Act. The lawyer's reference is 18 U.S.C. Section 1905. The lawyers in the crowd will recognize 18 U.S.C. as the Federal Criminal Code. That's the part of the code that gives you the electric chair if you shoot a federal marshal. And it makes it a felony for a federal official to disclose such data, and it's punishable by not more than 1 year in prison or not to exceed $100,000 per disclosure. And that could be an and. You get both thrown at you as a government official. That $100,000 comes out of the official's own pocket. So you will find that when you have appropriately marked your data, it's not likely to be disclosed. One short story, if you don't mind me telling a war story. I was in a conference room decades ago with a Army lawyer, and it was early in the SBIR era, and we were discussing marking, and he looked at me and he sneered, "What if I just disclose it?" And I did this to him. I kind of did that with my hands, and I framed him. And he said, "What are you doing?" And I said, "I just want to see what you look like in a jumpsuit." He changed the subject, and we moved on. Okay, next slide, please.
Dave, can I interrupt you again with a couple of questions?
Sure can.
All right. The first one is, what resources are available to small business concerns to assist them with marking their data? We often have businesses who do not know how to properly market, so they end up waiving their data rights.
Okay, got to know how to affix your data. The main resource is Appendix 1 of the SBA SBIR policy directive. Now, you don't need to sleep with the policy directive under your pillow like I do, but you should have it available so that you can resort to it and read that one section, Appendix 1, and in there is the legend. You can copy it right out of there, and you can get that clause, that policy directive online at SBA. So that's a great resource. Go to SBA, hunt up the policy directive, go to Appendix 1, and simply copy it. Don't copy it for the DOD clause. You've got to copy that out of the DFARS clause because DOD changed that legend a little bit. But another resource for instructions on marking that goes into a little more detail than I'm doing so here is a 15-minute tutorial on the SBA's website. And that tutorial is how to mark SBIR data. It is put on by a person fairly familiar to you. He's talking. So you can use that as a tutorial if that would be helpful. Does that answer the question?
Yes, thank you. And then we have a couple more.
Okay.
Would a direct award phase 3 be appropriate to a firm that has completed commercialization of its technology, i.e. there is no further development, simply sales or use? So away from the marking and a whole separate question.
Absolutely, it would be. Let's take a hypothetical. Let's say you develop a targeting technology for the Aegis cruiser, and the destroyer comes to you, and that Department of the Navy says, we'd like that similar technology. I know it's working on the Aegis, but we'd like it adapted to our destroyer and its slightly different targeting techniques. Can you do that? Absolutely. That would be the subject of a phase 3. What's that doing? It's extending the phase 3 to a different application. So not only can you commercialize and sell that, but you can continue to do new applications and different markets, different versions of it continually. And in fact, that's the value of the SBIR market.
Thank you. And then circling back to some data rights, we have heard some firms state that they want to support the warfighter or the country, and they want their data to be plug and play, interoperable, etc. And they intentionally want the government to have unlimited rights. Provided we have informed them of the impact, is it appropriate to continue with awarding a direct award phase 3 if the company insists on not protecting its SBIR data rights?
I'm not sure how that question is worded, but let me state positively, a firm should never agree to give up its SBIR data rights. Now, the government doesn't like SBIR data right restrictions of the type we've been talking about. Why? Well, because they really want the flexibility to do things with their people that the phase 3 firm can do. So the answer to that is, rather than give you plug and play data, why don't you give us a broad contract, an IDIQ, and issue task orders and tell us what you'd like to do with that data, and let's advance it in a way that gets it done. The firm that developed that data, that is developing that innovation, is the best source for advancing that to a product, to a usable platform, to any usable design or service. So I would say never give up your SBIR data. Why? We talked about it earlier. There goes your market. You've just given up your entire SBIR market. And if that product has a multi-hundred-million-dollar market, you just lost it. Think of what that would mean when you try and sell your firm. You'll get a $25 offer instead of a $25 million offer or better. So giving up your market just because federal officials ask you to do that is not advisable ever.
Thank you. And one more. Can you expand on the licensing of SBIR data?
Yes. The government retains a non-exclusive license because the SBIR firm can further license its data. Couple of points on that. If you license your data to a prime contractor to use to help integrate it into their much larger platform, I mentioned the Aegis cruiser, could be a tank, could be a submarine, could be anything. They need to be able to access the data and review it and use it. What you want to do is have a lawyer draw that license up and strictly restrict that license, that right to use. Think of your driver's license as the right to use a public road. The right to use your data strictly limited to the performance of their contract, and they can't use it for any other purpose. That is, they can't grab it and run with it and develop a product from it that you could have developed. So it's you, meaning the small business firm. So it's important to remember that licensing is a right to use, but it should be strictly limited in legal terms. And I like to advise to include liquidated damages from that. That's not a bucket of water if they violate the contract. Liquidated damages means a predetermined $100 million payment to us if you violate this agreement. The large firm will probably try and bargain that down to $1 million, but a hefty fine if they violate that license agreement. We're talking about protecting your market while you're giving someone access to your important data. That's called licensing it, and it should be done extremely carefully and under a carefully drafted agreement.
We have a late breaking question as well, Dave, if you don't mind one more.
Okay.
How detailed is the SBIR legend paragraph? For instance, for a SBIR phase 3, does it need to tie back to a previous phase final report?
It doesn't tie back to any reports. It is a pre-written paragraph that you put in verbatim. So you don't change it, you don't adapt it, you don't do any changing to it. It simply is inserted as it's stated in the SBA's clause, which is located at Appendix 1 of the policy directive, or in the DFARS clause deviation, where it is also set forth. And you need to copy that paragraph verbatim from the appropriate source.
That was all. Thank you.
Okay. Talking about that legend is pretty long, and it should be included on the title page of any submission that contains SBIR data. So you'll have the title of the SBIR, the innovation, whatever you have it, and you'll have that legend written out on the page in all 3 elements. Now, if you try and include that on every page, because the policy directive requires it to be included on every succeeding page, you're only going to get 1 or 2 or 5 lines per page on that, and your report's going to be 100 pages long instead of 20. Therefore, to avoid that kind of waste of paper, all of the agencies and SBA have accepted a shortcut for the succeeding pages. And I'm going to read it to you. It's on the slide. On succeeding pages in the footer, you can put this page governed by the SBIR STTR data rights legend set forth on the title page, which is incorporated herein as if written out in full. That's placing the legend on every succeeding page. And that shortcut allows you to save an excessively long report with the clause written out on every page in full. Okay, next slide, please. Here's some do's and don'ts. Apply the required legend to all documents containing SBIR data. irrespective of the type of funding agreement. I'm often asked, do we need to include it on an OTA? Yes, same as a grant, a contract, a cooperative agreement, even a task order under GSA, whatever funding agreements you have, make sure that the legend accompanies all submissions of SBIR data. A one don't is do not affix the SBIR data legend to a proposal. Proposals have their own protection of important substantive information, and that protection is located in the FAR. It allows the government to disclose some things, but not technical information like your SBIR data. So you rely on that protection and you don't include the SBIR legend on a proposal. Next slide, please. There is something called support services contractors, and they sign a non-disclosure document with the government. And under that agreement, they become bound by the Federal Trade Secrets Act, just like federal employees. So you don't have to worry about their access to your data. What are support services contractors? Think of their contract as allowing them to sit right next to a federal employee and see everything and know everything that that employee knows, and see everything that that employee reviews. So they may review your data, but under that non-disclosure agreement they signed with the government, they can't disclose it either. In reports and submissions, here's a little piece of advice: submit as little SBIR data as possible to be consistent with the award terms. So if the award terms, the statement of work, requires you to submit a certain amount of data, you need to do that. But I caution higher-ups in SBIR firms not to let the engineers draft the reports to the government, the phase 1 report or the phase 2 final report, because they tend to like to brag about all the data that they developed. And you don't want to submit all that data. Everything you can withhold from the government means they don't have the whole story. And so they couldn't possibly replicate your invention, even if they wanted to, because they don't have all the know-how that you kept at your disposal. So the government can't disclose what it doesn't know. Therefore, don't splatter your report unnecessarily with SBIR data. And above all, don't voluntarily disclose your SBIR data outside of the government without a non-disclosure agreement. That technically will absolve the government, release the government from its non-disclosure obligation. And so I say watch PowerPoint presentations to the government. When you get there with your PowerPoint presentation and you have your SBIR legend on the front page of that PowerPoint presentation, you have to be sure that all the attendees, both online and offline, in person, are federal employees or the special services contractors, and not someone from, say, a large prime that they want to get educated to your invention. Disclosing that data in the presence of the government to a non-federal employee could compromise that data, and the government could conclude in a letter to you, we're sorry, you disclosed all of your data in that PowerPoint presentation, and we're now going to release it publicly. So you can't voluntarily disclose your data to the public and then expect the government to honor a non-disclosure obligation. So don't do it voluntarily and don't do it inadvertently. Preserve your data at all costs. Next slide.
Dave, I have a couple more questions for you.
Okay.
Perfectly timed.
Get to them.
All right. If a company plans to use prior SBIR data, which is still within its protection period in performance of a new SBIR funding agreement, does the company need to assert SBIR data rights for that data?
SBIR data are data generated under SBIR contract or funding agreement. So if you are going to reference that data in a deliverable to the government, then you need to protect that data regardless of where it was issued. So if you have a combined document to the government that talks about your phase 1 data and phase 2 data, and now some prior phase 3 data, all of that is covered by your legend and you must mark it. So it doesn't really matter in a deliverable to the government what phase that SBIR data was developed. It still needs to be protected. If the protection period has run, I think that probably is not something you need to keep track of. I would just include it with the legend, which covers all SBIR data that still need to be protected. It would be the government that would try and parse that bit by bit and try and convince you that this bit is expired, but that's not. And so if they want to pick a few bits out and say that can be disclosed, fine, don't fight them. They can't do anything with it without the others. But mixed SBIR data all needs to be protected.
And then circling back to kind of the innovation area, successor and interest area, if a small business is in process of their phase 1 or 2 and is acquired by a large business, can the large business apply for a phase 3?
Absolutely. By acquiring the SBIR firm, the large firm acquires the prior SBIR data. And so they can receive a contract that is traces back to or derives from prior SBIR data because they now own it. Now you can't, as a large firm, license your way to a phase 3, and you can't subcontract your way to a phase 3. The only way you can gain phase 3 status is acquire an SBIR firm, novate an existing pending contract, or purchase, acquire some part of SBIR, prior SBIR work in the form of maybe a expired phase 1 or part of the technology or whatever. But certainly a large firm, once it's acquired an SBIR firm with all of its prior SBIR work, now qualifies for a phase 3.
Thank you very much. And that is all of the questions that we've received. I would encourage anyone, if they have any additional questions, to go ahead and type it in the Q&A box now, and we'll feed them to Dave and then end. But if we don't have any more questions, then we'll let you know. So I'll give it a minute, Dave.
Sure.
And of course, Rodney says a huge thank you to Dave, naturally.
Oh, you're welcome. My pleasure.
Any other questions or comments? Can we get a copy of the slides? Yes, of course. All right. Well, I think that's it, Dave. Again, thank you very much. I'll echo what Rodney says. A huge thank you to you. We really appreciate your time and your expertise. And I'm going to go out on a limb and say we may be reaching out to you if we have more questions.
Please do so.
Thank you.
Feel free. Okay, you're welcome.
We did have one other question. I'm sorry. If a company discovered a SBIR they owned due to prior acquisition, are they eligible for a phase 3, even if a similar solution is available in the commercial marketplace?
The answer is yes. The government may consider the other option, which is not an SBIR option, instead of the phase 3. So it would be vital in such a case with competing products out there to extol, that is kind of advertise the major advantages of your phase 3 potential, the innovation that is subject of the SBIR to the government and why it's preferable. And we see that quite a bit. Some of these innovations are, they bump up right against other products and approaches, and the SBIR firm has got to develop capabilities that are available only from it and are a big advantage to the government.
Okay, and so the follow-up is, so that would suffice, maximum extent practicable.
Yes. The existence of another product, an alternate product in the marketplace would probably prohibit a sole source contract, because it's not the only source for that product that is so similar it's not different. But when you're making an award without competition under Part 5, you can do that simply because of the fifth exception to competition. And it doesn't matter that there's a similar product out there.
Okay, and then looks like one more question continues, extends, includes work performed in phase 3s. How far award from the phase 1, 2 can you go with each phase 3 subsequent to that? How far can you go?
It's unlimited. Once you have a phase 1, you qualify for a phase 3, and you can skip phase 2, go straight to a phase 3 if the government wants to do that. It can do its research and development under the phase 3. Like I said, that could be an IDIQ contract, and you can continue it indefinitely. Now, there are some DoD limitations on the duration of awards. Those would probably apply to SBIR as well, but you can keep awarding phase 3s indefinitely.
All right, well, we have hit our time, so I will go ahead and close it out here. But again, thank you so much for your time and expertise, Dave. We really appreciate it. I hope everybody has a great rest of their day.
You're welcome. Thank you.
Bye-bye.